Please have a seat, and we'll call file number 2024-0198, State of North Dakota versus Andrew Stephen Janikowski. I'll note the appearance of Samuel Jurassic on behalf of the appellant in this matter, as well as Dylan Dyer on behalf of the appellee. Our sitting today are Justice Daniel Crothers, Justice Lisa Fair McEvers, Justice Jared Tufte, Justice Douglas Barr, and Justice John Jensen. Mr. Jurassic, whenever you're ready, you can take the podium. And feel free to adjust that podium to a height that's comfortable for you.
May it please, good morning, Justices, Counsel.
Actually, Mr. Jurassic, if I may interrupt you for a second, I'm going to have you, even though that may be comfortable for you, our microphone will pick you up better if you raise it up. Thank you.
Hopefully is that better?
Yes.
Okay.
Thank you.
Thank you. As you indicated, I'm here today on Mr. Janikowski's behalf. It's essentially a case about a waiver or non-waiver of right to counsel. And the Sixth Amendment right to counsel there's the right to counsel, and then there's the right to self-representation, and they're mutually exclusive, right? So one or the other. And if you're going to, and this court has the jurisprudence, if you're going to waive counsel, if you're going to want to self-represent, there needs to be an unequivocal statement. The desire of this court and other courts has been that we're going to presume right to counsel. We're going to reasonably presume against a waiver of counsel. And in this case, what we have is essentially none of a outright unequivocal waiver of counsel.
So if they're mutually exclusive, you have two rights and you pick one or the other and you say, I'm representing myself, aren't you choosing one over the other?
In an unequivocal statement, and I think that's why this court requires that unequivocal statement, yes. And what we have here is we don't have that unequivocal statement. So the presumption then should be he gets counsel, right?
Well,
that he's not.
If the district court asked him if he was representing himself and he said yes, isn't that an unequivocal representation? And this is after he's been given his rights.
It's not. Yes and no.
So you're saying a defendant has to say, I'm representing myself and I waive my right to counsel. Are you saying that?
It doesn't necessarily need to say I waive my right to counsel, but there needs to be an exchange, in a question. In this case, it's Mr. Janikowski, you're here today representing yourself. Yes. That's a statement, and he's yes, right? A question exchange needs to be, is it your intent to seek counsel, to apply for counsel? Do you want counsel? That there needs to be a question there. And then if his answer is no, representing myself, then you have an unequivocal. It's clear. And this court has said that ambiguity favors the denial of counsel, right? This court has stated routinely that they encourage the district court to avoid any ambiguity for this colloquy back and forth between the would-be pro se defendant and the court. So a statement of, you're here representing yourself, yeah, and that's it. And then later in that same hearing, the court simply states, maintain regular contact with your attorney should you retain one or have one appointed. Not, is it your intent to seek an attorney? There's no question posed to him. And then the very next hearing in February, it's again, you're here representing yourself. Yeah. It's not until the status conference in early June that the court says, and again, this is a statement, this isn't a question. Okay, and you are representing yourself at trial. Is it your intention to proceed with that trial? Not, hey, are you representing yourself? No, it's, okay, you're representing yourself at trial. Are we proceeding with that trial? And that's where there's no question. It's, you are representing yourself. And are you proceeding with that trial? The only...
How do you square that with what came next during the status conference?
Correct, and the only indication there is where he gives advantages, disadvantages, which I would argue that this isn't a complete advantages, disadvantages exchange, right? This is, and then finally, keep in mind that although you are not a licensed attorney, you are still held to the same standards as a practicing attorney would be, the rules of evidence, et cetera, offering evidence, making an argument, and that sort of thing, okay? All right. But again, it's not a question, you're going to be held to this. And what
Isn't that pretty clear affirmation that at that point, the defendant knew, clearly articulated he was representing himself at trial?
I guess I'm arguing no, because when we combine the first statement of you are representing yourself at trial, with that, just so you're aware, I'm going to hold you to the same standards. And when we look at other cases leading up to this, I mean, specifically, if we look at Rockwell, there was an exchange. There was a clear exchange with the court. It was, you're going to question all the witnesses, question mark. He's asking back and forth questions with the defendant. Here, there isn't that. There isn't
So is this a magic words case?
No, I don't believe it's a magic words, because this court has also said in the jurisprudence is that it's a totality of the circumstances type situation. We look at the totality of the case to determine if there is a functional equivalent of waiver or an unequivocal statement of waiver. And a lot of the jurisprudence, and I had trouble finding anything like on point to this case.
Because usually it's the defendant who is refusing counsel after repeated appointments of counsel, correct?
Correct, and a lot of the jurisprudence has to do with functional equivalence of waiver. There isn't, I was unable to find.
So what's the argument here? He didn't know that he had a right to an attorney? I mean, is that what underlies this argument?
No, I believe he knew he had the right to an attorney because he signed that rights waiver, right? But he has to waive that right, and that's the problem. So you have the right.
If you choose one thing, don't you waive the other?
But this court has required, okay, but the unequivocal waiver, along with an admonition of these are the advantages, these are the dangers, these are the advantages of having an attorney, this court has routinely required that exchange. Here we don't have it. We simply have a statement, I'm holding you to the same standards. Because it's already been established you're representing yourself. There's no exchange, there's no discussion before this of whether or not he, when he said, at any time, at any of the previous hearings, had there been a question of, is it your intent to seek out an attorney? Nope. That probably would have been enough. But again, I'm not arguing for a specific magic language or magic question interpretive. It's a totality of the questions, and there's none of the question here. It's
Well, you are asking for specific words then.
No,
Because if we looked at the totality here, he acknowledges he has a right to an attorney. He acknowledges that he has the right to have one appointed if he can't afford one. He shows up at all of the appearances by himself. He confirms that he knows his rights. You are asking for magic words. You're asking, do you waive your right to an attorney? Other than that, what could the court have done?
Had a colloquy at any time about these are the advantages, disadvantages, dangers of representing yourself. Or had a question. Again, that's why I'm saying I'm not arguing for a specific thing. Had there been a question of, okay, are you seeking an attorney? Nope. Then maybe you don't even need to go into the second set of questions. Or you're representing yourself. Are you aware of the advantages, disadvantages, and dangers of representing yourself? None of that was done. It was a mere statement of you're representing yourself. Yeah. You're aware of your rights. Yeah, I know I have a right to an attorney, but I don't know the advantages, disadvantages, and dangers of that, of invoking that right or not invoking that or waiving that right. I don't know that. And then finally, when we get right before the trial, all it is you're representing yourself at trial. Are we proceeding with that trial? The answer is yes, we're proceeding with trial. Not I'm representing myself. It's we're proceeding with trial. The statement is you're representing yourself at trial. And then the later statement is I'm holding you to the same standards as a practicing attorney. Not a colloquy of advantages, disadvantages, and that's,
Well, the courts discussing holding them to the same standard do talk about some of the very things that would be included in a Faretta warning about the advantages and disadvantages. The advantage of having an attorney is you don't have to know the rules, or you don't know how to select jury, or know the rules of evidence, or make I mean, isn't it just turning it on its head a little?
not necessarily. I guess the argument that I'm making is there needs to be a question. And here there was no question. It was just, you are doing this. And in doing this, I'm holding you to the same standards. That's it. And I think if there was a question or an exchange, it's somewhere along the way, the Faretta warning would have been satisfied.
A new question at every single hearing? I mean, there were multiple questions throughout this process.
No, I don't believe there would have, I'm not arguing for a question at every single hearing. That's not what I'm arguing about in any
So
way,
the
shape,
ones at the initial appearance and the prior hearing weren't sufficient.
just a question along the way. Instead, what we have here throughout every single hearing is, you're here representing yourself today. You're here representing.
Prior hearing weren't sufficient.
Just a question along the way. Instead, what we have here throughout every single hearing is, you're here representing yourself today. You're here representing yourself today. You're representing yourself at trial. Are we proceeding with that trial?
Right, but you're leaving out the context of him signing an express statement that he understood he had a right to an attorney. So you have to, those questions are all in the context of, you understand you have a right to an attorney, you understand that you have a right to one to be appointed for you if you can't afford your own. You're representing yourself? Yes. So it's in that context. They're not in isolation. Those two things work hand in hand, right?
Correct. But if we look at other areas of the law, when there's a change of plea, we require a colloquy between the court and the defendant. You are aware of your rights. You have the right to remain silent. You have the right to go to trial. You have these rights. Are you waiving these rights? Are you under the influence of anything at this time that could interfere with your ability? I'm not asking for that. I'm not arguing for that in any way, shape, or form. But I'm saying we do require a colloquy on other waivers. Here, yes, I signed the paper. It says I have a right.
Not only signed the paper, the judge then followed up with, you were sitting here when I read the rights to everyone? Yes. You understand those rights? Yes. So it's all in that context. It's not just in the blanket context of you're representing yourself. It's with the knowledge and understanding that he has read his rights and he understands his rights.
And that's step one. Step two needs to be, are you waiving that right? We required in every, sorry.
It sounds to me like you're asking for the magic word waive or waiver. That word has to be used in a question at some point. Is that the essence of the argument?
No, I guess I want to get away from a magic word or anything. It's that, as Chief Justice pointed out, there's a totality here. There's, we're looking at, he signed the rights waiver. Not arguing that that's improper in any way, shape, or form. It's the question of, are you waiving this right? And it doesn't have to be magically, are you waiving this right? It doesn't mean, are you seeking an attorney?
So it can be something other than you're representing yourself. Yes.
But that's a statement.
But the answer is not a statement.
But
The answer is yes, I'm representing myself.
But again,
Within the context of, he knows he has a right to an attorney.
but there again, it's a statement from the court.
But in the context of him knowing he has a right to an attorney,
Correct.
and knowing he has a right to have one appointed, his response is affirmative, I'm representing myself.
And if that's the reading, that this court takes, that question is in and of itself a functional waiver because he signed this rights form, then we need to go to step two, and are you aware of the advantages, disadvantages, and dangers of doing that? And we do not have that
So
anymore.
what specific advantages and dangers does the court have to point out? Because the court does point out that I'm going to hold you to the same standard as I hold attorneys. You're going to have to know the rules of evidence. You're going to have to know, and goes through a whole litany of things. What specific dangers does the court need to point out?
I don't know that there is a specific, and again, that's why I'm trying to avoid a magic language.
Well, what's
thing here.
missing then? If you can't
have to
point
re-
to a specific danger that's missing, what, you can't, it can't just be this, you had to use the word dangers. It had, what dangers weren't explained?
Okay. Right before that, he says, if you intend on having any exhibits and witnesses, you need to file that with the court. That's not, that's an advantage, disadvantage that with an attorney would know how to do that, would know what witnesses to call. The attorney would then examine, cross-examine. The attorney would
So when you
cross-examine.
explain to somebody what they need to do, you have to say, add to it, and it's a danger, you might not know how to do it. They can't figure out themselves that they don't know how to do it? If someone tells a defendant, you're going to need to file exhibits, they
Yes.
can't, internally, they're not thinking, I don't know how to do that.
We're talking about a constitutional right. And I think that's why it's so important that these things need to be very specific. We make district courts do it during a change of plea.
Well, let me ask you about that. What right under Rule 11 that a defendant waives has an equal and parallel right, like right to an attorney or right to represent yourself? Those rights, do they have another parallel exact?
I would say the right to remain silent. You either have, I'm speaking or I'm not. It's one or the other. I'm waiving that right, but that's a little bit different because if I start talking, that's pretty obvious.
That's what I'm saying. There are not similar parallel rights of an equal nature under Rule 11
And I think
waivers that are necessary.
But if we look at when the advisement comes from the district court during that change of plea process, it's by doing this here today, you're waiving that right, meaning I'm going to ask you questions about this factual basis, and you're going to have to tell me in open court and on the record. And you're going to have to waive that right, and you're going to have to talk to me. It's not one for one the exact duplication. The right to plead guilty, the right to plead not guilty and persist in that plea. It's they're not 100% equivalent, but they're comparable. And when we're talking about waiving constitutional rights, we require more than a suspicion. We require more than just a suggestion. We require an affirmative waiver.
Does a defendant have a constitutional right to plead guilty?
I would think so. They have the right to,
They have a right to a trial, so they waive their right to a trial by pleading guilty, but do they have, could a prosecutor say, I'm trying this case, I don't want your guilty plea, I want to try the case?
No.
Because the prosecutor wants the judge to hear all the evidence that's going to come in for a sentencing.
No, if the defendant walks in and pleads guilty, it's over.
That's how it generally works, but is there a right? Does the Constitution provide a right to plead guilty?
Without reviewing it right in front of me, I guess I don't know for sure, but based on context, yes, I would say that it does. Because again, it's the entire system is built around the defendant. I mean, we interpret laws in favor of defendants and ameliorative in favor of defendants. It's built around the defendant. So does he or she have the right to plead guilty in lieu of the prosecution saying, no, I'm trying this case?
What about the court? The court doesn't have to accept a guilty plea.
Without a proper factual basis, I think the court could reject it. But the court isn't in charge of what's the charges that have been filed. The court can't change any of those aspects. It's just presented with a case. And if a defendant walks in and pleads guilty, if the facts don't support it, absolutely, the court has the right to kick it, to say, no, I'm not taking that. But if the facts support the guilty plea to the charge.
So when a judge puts a limit on plea negotiations and says the plea has to be in by this date or we're going to trial, the judge can't do that?
I think we're way off topic. I don't know that. I guess I wasn't prepared for that question for this particular case. I don't know that. I don't specifically know that question, the answer to that question. I'm sorry.
I think some of our cases allow the court to consider whether the defendant has prior experience in criminal cases. I think that's in contrast to like Miranda waivers where you're not allowed to consider where the person already knows their rights. Is that allowed here? And if so, does your client have prior experience?
I think when I look them up, there is prior experience with the criminal system, but in the case law that I read, I don't see that. I don't see any mention to any reference to prior experience with the criminal justice system.
Okay. So if your client had had 5 prior jury trials, both with and without lawyers, that's not relevant to our determination here.
I would say no. Thank you.
Mr. Jurassic, thank you for your initial argument this morning. Mr. Dyer, whenever you're ready, you can take the podium. Feel free to adjust that podium to a height that's comfortable for you.
Mr. Chief Justice, Justices, Counsel, and may it please the Court, my name is Dylan Dyer, and I'm representing the Appellee in this case. As you pointed out, the Sixth Amendment to the Constitution and our own North Dakota Constitution grants the right to the assistance of counsel. However, as you pointed out, we have the right to remain self-represented. This court has routinely found, most recently in State v. Benter, that there is a 2-step inquiry to the waiver of counsel, that whether the waiver was voluntary and knowingly intelligently made, but as he also pointed out, it depends on the totality of the circumstances. And from the outset of this case, Mr. Janikowski gave no ambiguity for the court to work with that he intended to continue to represent himself. And at trial, the jury found him guilty of the crime he was accused of.